Good evening, everyone. My name is David Burton. I'm the police chief here for the city of Socorro, and we're in a small neighborhood here in the city of Socorro on Flor Celosia, and we have been doing some work over the last few days. We had some information that there was some human smuggling taking place. As with any law enforcement agency, we are very concerned when that occurs. We don't know if there's anyone that may be at risk here, so we took that information very seriously. We put together an operations plan, and then we came to this residence, and as you can, well, you can't see in the background, but we did rescue 6 individuals here, and they'll be going through a interview process so we can find out where they came from, where they were going, who brought them here, and then what the plans were, because it's safety. At the end of the day, we worry about safety and their well-being.
Chief, I know community policing is at the forefront of one of your management styles. Can you please tell us exactly who you had on hand here from other agencies?
Yeah, so we have a regional tactical team. So we cooperate with the Tigres. So the Tigres came today to help us out. I also have one of the individuals who's actually going through a school with us right now from Texas State. So he came here with us to take a ride as well. If you look around behind you, do a quick pan, you'll see that we have an ambulance unit here. And the purpose for that is obviously we're here for their well-being. This is not a criminal type investigation. This is a caretaking investigation. We're here for community services. So what we're worrying about now is, how are these people? Are they okay? So that's why the ambulance is right behind you. It also involves people like animal control. It involves the media. It involves the press, so we can get the correct information out to the public.
Chief, and just for clarification, there were no fatalities or injuries reported. We're just doing our due diligence to make sure that safety is priority for all of the victims here that Socorro Police has indeed rescued today. Is that correct?
That's correct. So there is no injury to anybody. We did this on a very low-level approach. Again, we're not looking at criminals, hardcore criminals here. There's a different way of doing operations when we do that. We're more concerned with the safety of the individuals inside this residence.
Speaking to the integrity of the police department, Chief, what can you tell us about the schooling that each of these officers has received and how they're properly educated to go ahead and provide the service here?
Yeah, certainly. So we ran this with a tactical operation. To even be on the tactical team, you have to complete the basic SWAT school first. As a matter of fact, they're going through it right now. That's a 60-hour class. That's TCOL certified. And then after that, there are some advanced classes in breaching techniques, shields, distraction devices, etc. Some of the specialty items that tactical teams carry. And then we do practice. We're very active, so we do practice twice a month. So we're out here for 16 hours doing this particular kind of drill.
What would you say to any of the neighboring communities, anyone that lives in the area, if there is a fear and you just want to put them at ease?
Yeah, so there's no danger to the public from this, right? It was a isolated incident. We work in the intelligence. We hit the residents that we needed to hit. We found the individuals that we were looking for based on the information we had. Now, I would ask for community help. If the neighbors are suspicious of this type of activity taking place in their neighborhood, call us.
And
where
would they call you to?
You can call us at the police department. This is not a 911. You don't have to call 911 on this. So our regular phone number is 915-858-9237. 915-858-9237. If it's anonymous, you don't want to be involved, that's fine. I have intel people that can work it. They're going to come and talk to you. We'll keep your name out of it, and then we'll take it from there.
Anything else you'd like to wrap up with, Chief?
No, I think this is a very good example of community outreach. Right? We're here to help people. We're here to rescue those that otherwise might not have a voice. And it's like I said at the beginning, this is no different than any other police department would do. I just want the community to know that the Socorro Police Department is on board as well.
You're watching Search and Seizure with Bruce Allen Barnard. Brought to you by Leah One, providing legal training you can trust.
Welcome and thanks for joining me today with this Supreme Court update that we have for you. I'm calling it the Caniglia conundrum, with the long-awaited decision in the Caniglia versus Strom case. And it's created some issues. It's actually left more questions unanswered than it has answered. And we've been waiting for this. I first analyzed this back in April of 2020, and right in the middle of the pandemic, and we talked about. I talked about the community caretaking exception, and then I fully explained the exception, went into a historical development of it. If you haven't listened to that podcast on Broadcast Blue, you can go to broadcast.blue or sign up for it on iTunes or Google Play as a podcast, and you can go back and listen to how I analyzed the First Circuit's decision back then. I really enjoyed reading it, especially because it's from a decision that was written by one of my favorite circuit court judges, Judge Bruce Selya, and always fun to read his decisions and have a dictionary handy because he's going to use some terms and some words that you're going to have to check yourself on. But we've been waiting for this. We knew this was coming. Some folks are acting like this was a big surprise. And there's a few podcasts and YouTube videos I've watched that came out kind of right after the decision. Everyone out at the starting gate, boom, let's see what we can get out there and grab some attention for ourselves there. I took a little bit of time to digest the decision, and also took the time to speak to some other folks about it. Talked to some other attorneys and some constitutional scholars and some police legal advisors, even trying to make sure that we're on board with this. See exactly what the proposition that this case stands for, and more importantly, what it doesn't stand for. So we're going to take a few minutes to look into that, and we're going to analyze it, and I'm going to share a perspective with you and see what you think. The full name of the decision, Caniglia versus Strom. It's a Supreme Court decision. It was decided on May 17th of 2021. Let's take a look at the facts. Here are the facts of this case as the Supreme Court announced in their syllabus. During an argument with his wife, Edward Caniglia placed a handgun on a dining room table and asked his wife to, quote, shoot him and get it over with. Instead of doing that, his wife left the home and spent the night at a hotel. And the next morning, she tried to call him on the telephone, but she was unable to reach him by phone. And so she called the police, concerned about him, based on what had happened the night before. She called the police and asked them to do a welfare check. And the officers responded along with Caniglia's wife, to the home. And when they got there, they encountered Caniglia, and he's sitting on the front porch. And the officers called an ambulance based on their belief that Caniglia posed a risk to himself or to others. Caniglia agreed to go to the hospital for a psychiatric evaluation on the condition that the officers not confiscate his firearms. So he made it very clear that he didn't want his firearms confiscated. Once he left, the officers located and seized these weapons, his firearms. Caniglia then sued to get him back. The police refused to give him back initially. It took him a long time to get him back. But Caniglia sued the officers in a 1983 action, claiming that they had entered his home and seized his firearms without a warrant in violation of his Fourth Amendment rights. So those are the fundamental facts that we have going on here. At the Circuit Court of Appeals level, the First Circuit joined several other circuits in extrapolating the community caretaking exception from the Cady versus Dombrowski decision and applied it to a dwelling. The court noted that threats to individual and community safety are not confined to the highways. And so under this safety umbrella, the court extended the decision, the exception from Cady, which was geared to automobiles. Remember in the Cady decision where they impounded a vehicle belonging to a police officer. They impounded the vehicle and then went into the trunk to look for a firearm. Since police officers back then usually had firearms that they carried with them in their personal vehicles, and they inventoried the car. They went in and searched the car looking for that. So that's the whole concept of the community caretaking function, and it dealt with just automobiles. The Cady case itself they were looking for a weapon, just like they were in this case, but it was directly limited to automobiles. Well, the First Circuit extrapolated upon that and said, hey, we're going to apply this to dwellings as well, noting that the threats to safety weren't just confined to the highways. And so that's basically what we're dealing with in this case. So the issue on appeal in front of the Supreme Court is pretty much straightforward. In fact, this is, as Justice Thomas announced, the question today is whether Cady's acknowledgement of these caretaking duties creates a standalone doctrine that justifies warrantless searches and seizures in the home. So in a unanimous decision, the Supreme Court held that the community caretaking exception that we have from Katie versus Dombrowski as applied to automobiles does not apply for the warrantless searches and seizures inside of dwellings. The court noted, and this is a quote, "What is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home." And they're referring to the Collins decision there. "We thus vacate the judgment below and remand for further proceedings consistent with this opinion." And so the court is just emphatically stating that the community caretaking doctrine does not apply to the homes. And, you know, the court also cited the Jardines decision. Just a quick little reminder, if you don't recall what happened in Jardines or what happened in Collins. The Jardines decision from back in 2013 was a year after United States versus Jones. And, you know, Jones involved the physical intrusion of an automobile, one of what Justice Scalia referred to as one of the 4 enumerated areas of protection in the Fourth Amendment. And the court said in Jardines that you can't do that, right? And it dealt with the curtilage of the home. The curtilage is that area around the home that is treated as if you're inside the home itself, and that the home is a protected place. And of the 4 enumerated areas, they've often referred to dwellings. The 4 specific areas of protection in the Fourth Amendment are persons, houses, papers, and effects. And houses are dwellings. It's where people live. And in many decisions, the Supreme Court has said that the home is the chief among equals. It is the place of particular importance and particular protection when it comes to the Fourth Amendment. In fact, in the Collins decision, Justice in the oral arguments, Justice Kagan referred to and referring to Jardines in the Collins oral arguments, basically said, you know, we've held that a person's home is sacrosanct, using that strong of language, you know, sacrosanct with regard to the protection that's given to the dwelling. So given Jardines and given Collins, this decision certainly isn't a huge surprise, and they really mean that when they say that the dwellings are sacrosanct. They genuinely mean that. They're not going to allow for some broad category that might be applicable to an automobile to also include the home. And we saw it in Collins, and refusing to extend the automobile exception into the curtilage of the dwelling, and we see it here again in this case. Justice Thomas mentioned exigent circumstances and talked about the possibility of exigent circumstances gaining warrantless entry into the home, and nevertheless reasonable under the Fourth Amendment through some type of exigent circumstances. And he went through the little litany. Now, it's important to note that wasn't on appeal here. The government never argued that there were exigent circumstances, so they stood alone on the community caretaking doctrine. If the community caretaking doctrine did not apply to dwellings, which the court held that it didn't, then it was a total bust for them. There was never an argument made that exigent circumstances applied. But Justice Roberts had a very short concurring addition to Justice Thomas's majority opinion, and that's because Justice Thomas didn't mention. He mentioned it by name, but he didn't cite a case support for the emergency exigency. He mentioned the Kentucky versus King case, which is one of our, the pinnacle, what I call the blue key case for the destruction of evidence exigency. But he didn't mention the Michigan v. Fisher decision, which is from 2009, which was the Supreme Court decision that dealt with the warrantless entry into the home on the objectively reasonable basis, believing that medical assistance was needed or persons were in danger. And that's the fundamental concept of the emergency doctrine. And unlike the destruction of evidence exigency, which requires probable cause, right? that's an exception to the warrant requirement, but not the probable cause requirement. The emergency exigency isn't based on the probable cause of criminal activity. It is more akin to the concept of someone needing assistance, kind of like the argument that was being made here in this particular decision. And so Justice Roberts basically provided a very short concurring opinion in which Justice Breyer joined, just acknowledging that the Michigan v. Fisher decision and the whole concept of the emergency aid exception are that type of exigent circumstances. And it's also important to point out, if you listen to, I believe it was nearly an hour and a half, they had extended oral arguments on this decision. And you'll go to the OIS website and listen to the oral arguments. You can learn a lot just from listening to the arguments that are made. Justice Roberts was very, very concerned about elderly people, about trying to assist elderly people. If there was some type of report that an elderly person wasn't answering the phone and had somehow missed out on their routine, and if you listen to question after question after question of Justice Roberts, it was clear that he was very concerned about this particular type of scenario. Ironically, he didn't mention it in his concurring opinion. Not to worry, both Justice Alito and to even greater extent Justice Kavanaugh in their concurring opinions jumped all over and specifically referred to the Chief Justice's concerns as expressed in his questioning in the oral arguments. But for his part, Justice Roberts just wanted to add to what Justice Thomas said by making reference specifically to Michigan v. Fisher, which was something that Justice Thomas didn't do in his concurring opinion. And so that was the extent of Justice Roberts' concurring opinion here. The decision in Caniglia is pretty straightforward, and it just basically stands for the proposition that the community caretaking doctrine does not apply to a dwelling. And that's pretty straightforward, right? So you think, well, what's the big deal with this? Well, the big deal is the conundrum that is created with questions that are related. I mean, we've relied upon the concept of the community caretaking function for issues such as welfare checks and as the basis of some of our statutory protection regarding red flag laws. And so the conundrum is, what does the Caniglia decision mean for welfare checks, and what does it mean for red flag laws? Now, neither one of these were addressed in the majority opinion, but they were addressed in a couple of the concurring opinions, one by Justice Alito and one by Justice Kavanaugh. So let's take a look at these concurring opinions to see what they say about these two particular situations, what they say about this Caniglia conundrum. Now, it's important before I jump to them, I want to point out that this is dicta. They're concurring opinions. They weren't a part of the majority opinion, and so they don't carry. They don't have the value of precedence, and stare decisis isn't going to be applicable. You're not going to be able to hang your hat on these concurring opinions, but they do at least let us know what two of the 9 justices think about the conundrum and their at least recommendations for how they would address these situations. Let's take a look at each of these two questions in turn. Well, the first question, what does this mean for welfare checks? We're going to look at both Justice Alito and Justice Kavanaugh's concurring opinions for just a little bit of guidance on what their thoughts are. And both of these justices recognize the Chief Justice's concerns. They're basically referring to what I talked about earlier, the questions and the specific scenario that the Chief Justice asked about in the oral arguments, went into great depth and great concerns about with respect to welfare checks on folks. And here's some quotes from Justice Alito. He said, "The Chief Justice's question concerns an important real-world problem. Today, more than ever, many people, including many elderly persons, live alone." And so he's recognizing, what do we do in a situation if the community caretaking doctrine is not applicable? then what do we do when we have these situations where we have people that are living alone? Maybe you have an elderly person that doesn't come to the door or answer the phone when called. They don't drive, or their car's in the driveway. There's no indication that they've gone anywhere. You don't expect them to have gone anywhere, and the loved ones or neighbors are concerned that no one's heard from this person, this elderly person that lives alone. If you what about that? What about that type of situation? But then he recognized the question, but then he said, and in part of his concurring opinion, he said searches and seizures conducted for other non-law enforcement purposes may arise and may present their own Fourth Amendment issues, but today's decision does not settle those questions. And so he recognizes that this is a problem, that this is going to create down the road. We're going to have, it might be back in front of the court, these searches and seizures for non-law enforcement purposes. But he's acknowledging that the decision wasn't, that today's decision didn't settle those questions. And again, it was very limited. The issue on appeal was just basically whether the community caretaking doctrine applied to the dwelling, and it didn't go into any other type of permissible warrantless entry into the home. Justice Kavanaugh went a step further in his concurring opinion, and when he talked about what does this mean for welfare checks, well, this is a quote from his concurring opinion. This Fourth Amendment issue is more labeling than substance. The court's Fourth Amendment case law already recognizes the exigent circumstances doctrine, which allows an officer to enter a home without a warrant if the exigencies of the situation make the needs of law enforcement so compelling that the warrantless search is objectively reasonable under the Fourth Amendment. He went on, and in dicta, he actually provided two examples, one regarding someone who was mentally ill and suicidal, a 911 call for a suicidal mentally ill person, and also he provided another example of an elderly person with no contact. We're unable to reach him on the phone or answer the door, and his questions, he would rhetorically ask a question and then answer it. Can an officer go in this situation? And then he would say flat out, yes, he can. So Justice Kavanaugh would apply, clearly, he would apply the emergency aid exigent circumstances exception to those two types of situations and potentially others. So he was fully prepared to let everyone know that if there was a case in front of the court involving warrantless entry based on those types of examples, he would certainly be willing to apply the emergency aid exigent circumstance exception to those two types of circumstances and possibly others. So he took it a step further in his concurring opinion. So this gets us to the second question, and kind of saving the more interesting one, I guess, or the one that a lot of folks in the police community and police legal advisors are really worried about. What does this mean for red flag laws, and what's this going to do for all of these so-called red flag laws? And there are different states that have different statutory provisions. My home state of Florida has such a law. There are other states that have them as well. And Justice Alito was the only one who mentioned them or addressed them in any way of substance in his concurring opinion. And again, it's a concurring opinion, and it doesn't really provide us anything, but it does point out kind of states what we already know from this decision, and he fully acknowledges that these provisions of red flag laws may be challenged under the Fourth Amendment, and those cases may come before us. But our decision today does not address those issues, and so it's kind of out there. What are we going to do about what's going to become of these red flag statutes and they vary greatly from state to state as to what's required and how they have to go about it. But basically, where the statutory, you have these risk protection orders where the law enforcement officers are able to go in and seize firearms from an individual because they present a threat to the community. There's a risk that their possession of the firearms creates, and it mostly deals with folks who are mentally ill. And it's a quagmire, and we're certainly going to have this come up. It's certainly going to be a case. You're certainly going to have an issue where there's an RPO issued and someone's firearms are taken away, and then we're going to end up with Second and Fourth Amendment challenges to not just the confiscation, but the statute that calls for it, which is the red flag law itself. And so we can fully expect to see that. There's no answer to that question in this particular case. All this case makes it clear is that to the extent that the red flag laws were based on the notion of the community caretaking doctrine being applicable to a dwelling, then there are going to be issues with that. And so that's something that we're going to have to wait and see how that pans out. And surely it won't take long before we have some cases up in front of the circuit courts of appeal. And I'm fully guessing in front of the Supreme Court before too long regarding these scenarios and these red flag laws. So now we get to the money slide. We get to the most important part. And what is the takeaways? Specifically, what are our takeaways from this decision, and how can we use this decision? What do we have to know about this decision, and how is it going to impact us in law enforcement? Well, first, and most importantly, I want to point out that the court stated it in Jardines, it stated it in Collins, and it's making it clear again in the Caniglia decision that dwellings are truly sacrosanct. The dwellings, the protection of dwellings, the chief among equals of the protected areas of the Constitution, they're going to give that extra bit of scrutiny, and they're going to that extra bit of protection to dwellings. They've been very consistent in that regard, and I think there's no reason to expect anything different in the future. And dwellings are truly sacrosanct. The next takeaway that we have. The single most significant part of the decision is the community caretaking doctrine does not apply to dwellings, period. And I'll just leave it at that. It doesn't make it any more clear. It can't be made any more clear than that. What about emergency welfare checks? What about these welfare checks that we do for folks? If we don't rely on the community caretaking doctrine, what do we rely on? I think you follow the roadmap. You follow the roadmap. The Chief Justice kind of articulated the concern in the oral arguments. Both Justices Alito and Kavanaugh directly addressed the concern and said, hey, look to the emergency aid exception or the emergency exigent circumstances exception, whatever you want to call it. The emergency exigency is what I typically refer to it as when I'm teaching my folks. And if you look at the Michigan v. Fisher case, the standard, I think, to quote the court in that decision, it's just not that high. We're not talking about probable cause of criminal activity for the emergency aid exception. We're just talking about a reasonable belief that there's someone in need of aid inside of that dwelling. And the key to this is articulation, right? Develop the facts that you can articulate. Listen to what the Chief Justice, listen to the hypotheticals that the Chief Justice put out in the oral arguments. I mean, it's an hour and a half long, the oral arguments for this particular case on OIS, OYEZ.com. But if you have the time, driving somewhere someday, just to listen to what the hypothetical scenarios that the Chief Justice posited, or read the hypotheticals that Justice Kavanaugh put forward in his concurring opinion, you'll see that you can articulate the facts. If a neighbor calls and says, I haven't seen Miss Smith in 2 days, is that enough for you to go kick the front door down? No, it's not. But keep adding facts. What are you going to do? You're going to knock on the door. You're going to get more facts. Do you typically see her? Does she typically go anywhere? Is there a place? Does she have a routine that she's not following? What is the basis of your concern? And be able to articulate the facts. And again, going back to Michigan v. Fisher, it's just a reasonable belief that there's someone that needs help inside, and the threshold just is not that high. Just articulate the facts. And And for a lot of these emergency welfare checks, if they're truly an emergency, then you're going to be able to use the emergency aid exception, the emergency exigency exception, and so. But you're going to have to. It's going to have to truly fit fit the exception, and it's going to require more than just a report. It's going to require a little bit of effort, additional facts that you can articulate that lead to that reasonable belief that there's an emergency in there. And what does this mean? Lastly, what does this mean for red flag laws? We don't know. I mean, they're not going to be able to hang their hat to the extent that red flag laws were based on the presumption that the community caretaking doctrine would apply to dwellings. Well, that presumption is gone. It's clear that that's not the case. And so the red flag laws we're going to have to look at them and see what the basis is for these red flag laws. It might be that the court has to create a different exception for the red flag laws, or it may not. Might shoot them down altogether. We have to wait and see what's going to happen. Anyone that's going to try and predict these laws are so different and so varied from state to state. Anyone that's providing you a blanket prediction that all red flag laws will disappear, well, that's a little grandiose, and I'm not going to go that far. But there is a problem to the extent the red flag laws rely on the community caretaking doctrine for validity. Then there's going to be a problem, and we're going to have to wait and see how that pans out, and surely it will in the not too distant future. Well, that's it for this Supreme Court update. We've got another Supreme Court decision pending regarding the hot pursuit doctrine. I can't wait for that decision to come out. It's going to rectify the differences we have among the circuits on what's actually required for the hot pursuit exigency. That one's probably next on the radar, and we'll certainly have an update for you as soon as that comes out. But I want to thank you for joining me for this special edition of the Supreme Court update. And from the folks here at Leah One, we want to let you know that we're back in business. We're out doing live training again. If you have any training needs for the legal aspects of law enforcement, we would be absolutely delighted to either do that at your facility, do it online for you, and we're even working on on-demand courses. Have 3 very popular courses right now that we're going to do a total on-demand, and we're going to have state-specific versions of them on demand. I mean, all this stuff, webinars are great for information sharing if you've got the time to sit somewhere, but the on-demand training, we all know that's where the future's at, and we're leading that. Leah One's lead, we're taking the lead on this on-demand online training. I also want to specifically invite you, for police legal advisors that are listening to this podcast. We are doing a new iteration of the Police Legal Advisor Training Program, PLATP. It's going to be coming up this August in Cocoa Beach, Florida, at the Cocoa Beach Hilton Oceanfront from August 3rd to August 6th. That's a Tuesday through a Friday. 4 full days, 32 hours of instruction, including 4 hours of ethics for the folks that need that for CLE or applying for CLE certification in Florida and Kansas. And we would be happy to apply for CLE certification in your state if you would like to join us. Seating's limited. We just recently announced it, and we have sold approximately a quarter of this available seating already. If you go to the Leah One website at www.lea.one, you can get more information about the Police Legal Advisor Training Program that's going to be this August, and we hope you can join us for that. Until next time, thank you so much for joining us for the podcast, and thank you so much for what you do. And we hope to see you again real soon on another episode here with Broadcast Blue and Leah One.